We'll also weigh in on other cases that we are following for you today, including the Gauteng High Court in Pretoria. Now, it has dismissed with costs the Democratic Alliance application to have the Cadre deployments for the ANC declared unconstitutional.
The order of the court is as follows. 1. The application is dismissed with costs. Roman 1. The costs include, in respect of the first and the third respondents, the cost of 5 counsel with 1 senior counsel. Roman 2. In respect of the 4th to 5th respondent, the cost of 2 counsel, including 1 senior counsel. And in respect of the 6th respondent, 2 counsel with 1 senior. I hand down the judgment.
All right, for more on this judgment, we are joined via Teams by Senior Legal Analyst and member of the Legal Practice Council of South Africa, Advocate Romeo Nthambeleni. Advocate Nthambeleni, thank you so much for your time this morning. Just talk to us about the key implications of the Gauteng High Court's ruling in favor of the ANC, essentially regarding its cadre deployment policy.
Okay, good afternoon, and thanks for having me. I think that the court looked at the merits of the application and found out that they cannot declare unconstitutionality of the cadre deployment policy of the ANC, because what the DA was asking was a high threshold of actually declaring the entire policy unconstitutional. But I think also it's not going to be the end of the matter. I believe that the DA will still want to maybe launch a leave to appeal for the order that was granted by the court today.
In fact, just getting into that, I mean, we heard the DA leader, John Steenhuisen, just minutes after that judgment was made, saying that, in fact, he doesn't believe that the court applied its mind. I mean, from a legal perspective, what factors, likely influence then the court's decision in this matter? Yeah,
that's a good question that you're asking. I think constitutionality it's a high threshold, and when the court is seized with such a matter, they look at what are the elements of constitutionality that are offended or allegedly breached by the statute of the law. And unfortunately, I think in this matter, the DA was unable to actually prove that that policy in its entirety offends to the Constitution, and hence the court ruled that that application ought to be dismissed with cost. But obviously, in terms of the structures of the courts in our country, the High Court has the power to actually look into the constitutionality of any legislation and declare it invalid to the extent of its inconsistency with the Constitution.
And just looking at, and you mentioned it a little bit earlier, of course, we now know that the DA is intending to appeal this matter. I mean, what are their chances?
Yeah. The prospects of success depends on the court acquis, the court that dismissed the application, to check if ever there's merits in the leave to appeal itself. And if they find that there's no merit in the leave to appeal, they will obviously deny the leave to appeal. And what will then happen is that the DA will be left with no other alternative but to petition to either the full bench of the court or the Supreme Court of Appeal. So I think, if depending on whether the judges that have dismissed the application agree with them that the grounds which they are bringing for leave to appeal have substance in them, then it might be quicker. Then the matter, depending on how they frame their application, might either go to the full bench in the same court or the Supreme Court of Appeal, who will then relook at the matter to actually make a determination.
And another matter, and of course, in another court case that we are tracking, and of course, this is one of those prominent court cases in the Thabo Bester matter. A number of things came out there. I want to touch on the change in terms of the sequence of the accused. We now know that Dr. Nandipha Makudumana is now accused number 1, and Thabo Bester is accused number 7. There were previously 3 and 4, if my memory serves me correctly. I mean, what does this all mean in terms of that change in sequence? I mean, a lot of questions also being raised. Does it mean now that Nandipha Makudumana is perhaps the mastermind in terms of this escape?
Yeah, the sequencing is key, because normally when that happens is when investigations are ongoing. Every time when the matter appears in court and it's being postponed, we hear that investigations are still continuing. So it means that the investigations thus far has gathered that the sequencing of the accused persons must be changed. And as you have said, Nandipha Makudumana should be placed as accused number one. Being, as you have correctly pointed it out, the mastermind behind, and then Thabo Baxter being put as accused number 7. So that is, for the court and the NPA when they're doing prosecutions to know, because this trial has got many accused. What type of sequencing are we actually going to have in terms of bringing the accused persons charged before the court?
And now, like I said, this was meant to be, a pre-trial. Just talk to us about the significance of this pre-trial. I would imagine it is to determine the readiness of the actual trial.
Absolutely. Pre-trial is precisely for that purpose, so that when you are running a trial, you don't find out that there are things that you were supposed to have organized during a pre-trial that are not organized. You heard the judge was also speaking about the issue of fees, and that are the counsels that are on the matter properly being placed on funds, because you might find that during the duration of the trial there's withdrawals which actually affects the process of the trial itself. So pre-trial is housekeeping in law. All the issues that need to be sorted out before the commencement of the trial, and then there can be a forecast of how long will the trial run, how many witnesses will the state call. You heard that the state was saying, setting out more or less how many weeks the trial will actually run. So pre-trial housekeeping to make sure that things are in order.
All right, Advocate Nthambeleni, thank you so much for your time. Of course, that was Senior Legal Analyst and member of the Legal Practice Council of South Africa, Advocate Romeo Nthambeleni, just weighing in on that Thabo Baxter trial or case rather. And of course, weighing in earlier on the Gauteng High Court in Pretoria, dismissing with costs the DA's application that the long-standing ANC policy of a cadre deployment be declared unconstitutional and unlawful. Let's continue with this now. The ANC says it's emboldened by the High Court decision this morning dismissing the DA's appeal to have cadre deployment declared unconstitutional and unlawful. Party spokesperson Mahlengi Bengu Mutseri was speaking just outside the court. She said ANC Secretary General Fikile Mbalula will address the nation tomorrow for a more comprehensive response in this matter.